SJC-11693, Commonwealth versus Nyasani Watt et al.
Good morning.
Ms. Doherty, good morning.
May it please the court, Elizabeth Doherty. I represent Nyasani Watt, one of the defendants in this case. As you know, Attorney Greenberg and I are going to be splitting the time. I will be addressing the issues that I prepared in the brief, the expert witness issue, the police expert witness issue on gang testimony, the prior shooting, and to the extent that there's time, the improper admission of the cell phone evidence. I'd like to begin with the expert witness testimony. And to this end, I'd like to read a quote from Mejia that's cited in this court's recent decision in Commonwealth versus Wordsworth. This case actually reflects the problem with the expanding use of police expert gang testimony when it's beyond sort of sociological evidence and also beyond the personal knowledge of the witness. So to that end, this is the quote from Mejia. An increasingly thinning line separates the legitimate use of an officer expert to translate esoteric terminology or to explicate an organization's hierarchical structure from the illegitimate and impermissible substitution of expert witness for factual evidence. The officer expert transforms into the hub of the case, displacing the jury by connecting and combining all other testimony and physical evidence into a coherent, discernible, internally consistent picture of the defendant's guilt. When expert testimony about a gang's history, territory, colors, hand signs, graffiti use, naming practices, tattoos, structure, membership rules, and similar sociological evidence can assist the jury in understanding and evaluating evidence concerning the specific crimes charged. But there is no sociological expertise in testifying to, for example, that a particular defendant is a member of a particular gang. When the expert's testimony on such matters is not based on personal knowledge but on testimonial hearsay, the testimony not only violates the rules of evidence but also the confrontation clause.
Can I ask you on that issue? The gang expert here never came out with the conclusion that he was a gang member. But in this case, it's somewhat unusual in that we have a number of civilian witnesses who testified to the beef in gang membership and wanted to protect it. Can you go through the civilian witnesses, and doesn't that really speak as to whether or not there was prejudice in the case when there was an adequate evidentiary foundation based upon civilian witnesses, unusually so in this case?
Well, I will address that question.
Could you answer my question, please?
Yes. Well, I just before I do, I wanted to say that I believe that he did make a conclusion based on his collective knowledge. I would dispute that premise. I would argue there were three, from my counting, civilian witnesses that testified that they were in a gang. Those witnesses testified after Detective Sarah testified, and Detective Sarah had testified to his conclusion that they were members of the Flatline Gang. I would submit that that in itself speaks to the prejudice. It conferred reliability on those testimonies. One of those witnesses was Jeremiah Rodriguez, who in the brief we've discussed had rife with problems, was a childhood schizophrenic, his testimony was all over the place. So that tended to confer reliability on him. Another one.
Two others didn't have that baggage, right?
What's that?
Two others didn't have that baggage that he had?
Shawanda Rodriguez was a truly reluctant witness who came into court, was appointed an attorney in order, and so her testimony, one could obviously speak to fear, but also could could speak to her not wanting to come in and be confronted with making up a story. And then Elijah Rodriguez did testify as well. His was not as rife with that kind of baggage. But I would submit that having that testimony of Detective Sarah beforehand, this court is well aware of the imprimatur of official.
Have any of our cases in this area, where we have a lot of them, ever discussed the gang expert in the context of having other evidence to show that? Because usually it's just someone from the Boston Police, usually, or another police department that says, I'm familiar, and we get into the whole hearsay levels, which you've done a great job laying out for us. But I don't think any of our cases have talked about independent evidence of this.
Well, that is true, that in Wadsworth, it does appear that it was just it's not clear entirely, but it does appear that in Wadsworth, it was just the expert witness that was there. But again, I would state that his testimony and the order of his testimony, and he was clearly qualified as an expert, would tend to speak to the prejudice of his testimony, and again, conferred reliability on civilian witnesses. I mean, if they had the expert plus the civilian witnesses, why not just have the civilian witnesses if that was the case?
So you say he was qualified as a witness? Was there? Did the judge say you are now qualified to testify as an expert, or did the judge simply allow him to testify as an expert?
The judge did not formally qualify, as happens in most of these cases, where they're not formally qualified before the jury. But it was very clear that he was an expert. He spoke extensively on his experience before he got into the substance of his testimony. So I think it would be clear to the jury that he was being presented as an expert.
He did have experience.
Yes, he did. But as they say, while he was not qualified as an expert for the jury, it would have been clear to the jury that he was an expert.
So what are the opinions you say are so problematic by Detective Sarah that they warrant reversal? That there was that Blake and Elliott were from the Geneva-Everton gang? Did he testify to that?
He did not testify to that, I don't believe.
So
There was really no evidence that they were of the Geneva
They
Everton.
just happened to have the misfortune of living in that area.
Exactly.
Okay, but he basically says there was that Mattis and Watt were gang members of the Flatliners.
Yes, and based on his collective knowledge.
And did he testify that there was a beef between Flatliners and Geneva Everton?
He did testify to that, and he had no personal knowledge about that whatsoever. And that all of those pieces.
Wait. When you say he had no personal knowledge, what do you mean? Because there is a collective knowledge doctrine for police officers, isn't there?
There is a collective knowledge doctrine for police officers, and I looked at it because I was sort of searching collective knowledge, and it doesn't tend to come up in the context of expert testimony. It tends to come up in the context of motions to suppress and for what constitutes probable cause is what I've found, and I don't think that.
Yeah, I'm just wondering if this was in his jurisdiction, and if he's at roll call, at shift change, he's going to learn things,
Well, we don't know. We don't know where it comes from. It comes from this amorphous collective knowledge. But the number of things that Detective Sarah did not know are striking, or that he had no particular knowledge. And these are all pieces that are necessary to make sense of this offense. He did not have any personal knowledge whatsoever of the workings of the Geneva-Everton gang. He had no personal knowledge of any sort of beef that went on between the two. In fact, I think that was brought up during trial. They based they base there being a beef on incidents that took place almost 2 to 3 years before the offense at issue.
There was a motion in limine, and we're looking at abuse of discretion, correct?
Excuse me?
There was a motion in limine, and we're looking at an abuse of discretion
Yes.
standard.
Yes, and I would submit that this is clearly an abuse of discretion to admit his testimony. Not on, to clarify, there were pieces that Detective Sarah could have testified that I suggested in the quote that I read. The history and structure of gangs in the Dorchester area, his knowledge of.
Can you have a site, because the Commonwealth says that Detective Sarah could not and did not identify the defendants as members of Flatline. You dispute that?
I do, and I would.
Do you have a site
Yes, I
for
do.
me?
It's in volume 6, 164 thereabouts, and then volume 6, 168 to 169. Those are in that area.
Thank you.
They have volume 6, 235, 236, 245, 248 for the proposition that the expert did not testify that they were part of the gang, but only testified as to motive and as to territory.
I'm not sure about that. I thought 235 and those pages referred to one of the civilian witnesses' testimony.
That's right. In other words,
Yeah.
that the civilian witnesses testified, and as Justice Gaziano said, that the expert did not identify the defendants as members of Flatline. That's what they're saying.
Detective Sarah did not himself have knowledge that they were of that. He based it on his collective knowledge that I would argue is suspect and not
But
sufficient.
is the Commonwealth wrong that the expert, in fact, did say, no, these defendants are members of Flatline?
Based on his collective knowledge at the pages that I cited.
Okay, all right.
In fact,
I think he testified specifically on page 169 that based on the conversations that I just had with police, with colleagues in the police department, as well as community contacts, they had met some of the criteria to be met to be categorized as a gang member. So that's what he testified.
yeah, on page 164, he was asked, do you have any collective knowledge between 2007 and 2011? Just whether you had knowledge, do you have any collective knowledge about whether Nyasani Watt and Sheldon Mattis were members of the organization in that time?
So I guess the dispute between you and the Commonwealth is that they're citing that he himself didn't say it, but he said that collectively the police think they are.
Well, and in fact, therein lies the problem with many of these cases where the expert is not testifying based on his, he has no basis of knowledge, as was held in Commonwealth versus Wadsworth.
Well, you
And
wouldn't have any problem if the 3 civilians testified first, and then there was a hypothetical or assumed facts, and then there was testimony about the implications of territory with gangs and motive, would you?
Those would be territories and those kind of things. Those would be beyond the ken of the average juror, and they would have assisted them. But what he testified to, based on his collective knowledge, not only was it hearsay and acting as what they would call like a case agent, summarizing evidence, but it was also evidence that is not what an expert witness is supposed to do in these cases. They're supposed to set forth information that's going to assist the jury in making a determination.
But an expert witness can properly testify to evidence that's before the jury, correct?
Yes.
So in Justice Lowy's question, were he to testify after the civilians, that information would have been in front of the jury and we would have been good to go?
I wouldn't have as much of a problem with it, I guess, if it took place afterwards. And I cannot dispute that
Which goes to prejudice, I assume.
it does go to prejudice. It was highly prejudicial that this particular detective came in and testified to an issue that was crucial. And again, as I say, while he was not qualified as an expert before the jury, it was clear that he was an expert.
Can't ask him to be qualified before the jury.
Right, right, well, exactly. But I mean, he was not, but it was clear that they were, that he was an expert. And they testified about his qualifications. I'd like to touch on another point that's interesting, that is different than Wadsworth. In this case, there was much testimony, both during his voir dire testimony and then some at trial, that the way that the Boston Police Department qualifies or determines, not qualifies, but determines someone being in a gang is to be placed in the gang database. These defendants were not in the gang database.
But that came out at trial
It
abundantly.
did come out in trial, but he testified, despite that, that they were members of, inconsistent with what he had testified, that the gang database is the way that people are determined. So not only were there problems that he was testifying beyond what an expert should testify, beyond sort of the sociological type of things that, and history of the gang and practice and some whatever that would assist a juror. Not only was his testimony not based on his personal knowledge, not only was his testimony based on hearsay, acting as a case agent, sort of summarizing this for the jury, but also he testified inconsistent with what his own testimony was.
Except for being in the gang database isn't the end-all be-all about whether someone's actually a gang member, is it?
Well,
That's not what you're saying.
Well, that was essentially his testimony during the voir dire and during trial, that the Boston Regional Intelligence Center is the entity that determines gang membership.
You don't want that to be a rule for the defense bar, do you?
Excuse me?
If the brick says your client's in a gang, it's over, you don't want that to be the rule.
Well, in this case, they said they weren't. So in this
Right,
case,
but like you don't want to leave it to the brick to determine who's in a gang, right?
well, I mean, again, in this case, perhaps I do, but you know, perhaps in another case I might think differently. But in this case, they determined that they weren't.
Was he crossed on that?
Excuse me?
Was he crossed on that? Was there a cross-examination
He
on that
was
issue?
crossed on that, about that, but again, he had already at that point testified that, you know, despite them not being in the gang database, that based on his collective knowledge, who the heck knows what that is, based on his collective knowledge, they were members of the gang.
Okay, you've got other issues, so you only got a few minutes more, so you better get to them.
The other issue I'd like to speak to is the prior shooting that was admitted. And again, I have a quote that I'd like to read from Wadsworth, and this is at page, it's 482, Massachusetts, 454, 467, and this is note 27. In Wadsworth, this court rejected the defendant's gang membership could be surmised because shootings had occurred in the defendant's neighborhood. One need not be a gang member to be present for or the victim of a shooting. Individuals may be present during a shooting, not because of anything they did, but because where they lived, which I think once a member.
But that was offered as evidence of motive, not necessarily of gang membership.
No, no.
That basically T-Mac's house had been shot at, right?
Well, this is the evidence that they had that well, I don't think it connected it to. There was evidence that there was a shooting 11 days before the shooting at issue, and they found
Shooting at 6
Levant Street.
Levant Street, which
Levant
was
Street, yes.
T-Mac's home and supposedly the hangout for this particular, the Flatliners.
Well, yes, but that really is all that they had, that there was a shooting. And as I pointed out in the reply brief, this is the Bowdoin-Geneva neighborhood is the shootings occur there 4 times more than any other part of the city. And that a random shooting took place without anything more to connect it to this particular issue is wrong. There was nothing more to connect it to this.
It's not a neighborhood, it's a particular address that there's evidence is the quote-unquote headquarters.
Well, yes,
Not the area.
That's right, but that shootings take place in this particular geographic area, including this street.
I know, but that's not the relevance. It's 6 Levant Street, then that happens to be headquarters and admitted, as the chief said, on the issue of motive, that this is some sort of turf retaliation. Whoever might have thrown the first punch, I don't know.
As I say, all that was relevant to this was that there was a shooting at this particular address. I would submit there has to be more, that this is suggestive of just a random shooting in a violent neighborhood. And to connect it to motive, I understand that motive is generally admissible, and there tends to be liberal admission to this, but without more, to connect it to this particular issue was highly prejudicial to the defendants.
One last question. There was a reference, I gather, according to the briefs, I've not gone back to the transcript, in closing by the ADA that TMAC had said after this shooting that something has to be done about it.
That's correct. And I searched through the transcript and could not find any reference to that. And I would submit that exacerbated the prejudice here.
So you're saying that was prosecutive error unless we can find something in the record to support that?
Yes, as I say, I searched through with diligence.
Didn't the civilian witness say something about we take care of our own or something?
We take care of our street, or we watch our street, or whatever. But I would submit that that's too vague.
And was that attributed to TMAC or someone else?
I think it was attributed to someone else.
Okay.
If there's nothing more, I will.
And we know that you've also included in your argument claims with regard to the cell phone, and we'll take those into account.
Yes, thank you.
Ms. Greenberg.
I represent Ed Al, who is actually a person that would be Sheldon Mattis, who was 18 years old. And when this court does its plenary review and looks at all these arguments as a group, you might look at what evidence goes against Mr. Mattis as opposed to what evidence goes against Mr. Watt, especially with regard to gang membership and what establishes it.
Attorney Greenberg, this might not be relevant to this particular case, but I'm just curious because you seem to be familiar with the research in the area of the brain science and all of that. Is there a point that has been identified where the development stops and you can officially say somebody's crossed over the line into adulthood or mature thinking, or is the brain always developing?
Judge, as we all know from our common experience, at some point the brain starts going downhill.
Yeah, well, maybe a little more than
That
we'd
would
like.
actually be that would be somewhere around 34.
34.
Is established for going downhill.
So
Improving the science is firmly established as to up to 21 and less firmly established as to up to 25. But certainly leaping right into the issue I had not meant to address till last.
I know, I'm sorry.
Yeah, no, just, I don't want to run out of time.
Before
But-
we'll
go ahead. I'm
we'll
sorry.
get to that. Why don't you go to let's stick with the issue that you mentioned. You offered the affidavit of Robert Diaz.
Yes. Licensed private investigator Diaz.
Right.
And who
I've got
worked
the
with
affidavit. Right.
2L.
Who says, now, I don't know from the record, I guess they were making reference to a map in terms of where JR was when he said he heard this.
It's Exhibit 1. There's a corner of Geneva and Levant. There's like sort of a stone mountain thing in the middle. If you stood on the Geneva side, no one can see you. So the, Jeremiah Rodriguez reports saying, we can see them from there, can't be right. And if you stand on the other side, you can't hear them. So
JR say precisely where he was when he saw,
yeah, he's sitting on
gun?
his front porch.
so he was sitting on his front porch.
Right, and he says he can hear, but he can't hear. From the place where he could see, he could not have heard.
But he can see.
Either, well, if they were standing in a different place, maybe they could have seen, but he couldn't both see and hear. The description of what he saw puts the two in a position where he could not have heard. And it's clear from the map, and it's clear from the affidavit, he could not have heard. And if you look at the, as my sister points out, the extensive impeachment of Jeremiah Rodriguez, he doesn't hear this conversation until he suddenly recalls hearing the inculpatory conversation only in the middle of the trial for the first time. And he only recalls seeing in the middle a gun go in the middle of the trial for the first time. His testimony becomes increasingly inculpatory in direct contradiction to his grand jury testimony as the trial progresses. In stunning surprise, I think I give the DA credit, in surprise to the DA and in surprise to the defense. Nonetheless, that overheard conversation as to Mr. Mattis is the whole ballgame.
Well, I mean, combined with are you saying that he had never spoken about Mattis giving Watt the gun?
He didn't see it, and he didn't hear the conversation.
So what evidence was given in opening, or what evidence was promised in opening by the Commonwealth with regard to Mattis's involvement?
That he saw them meet behind that he saw them meet behind a car. And then the inference of guilt which come from conversations which take place after the event is complete.
So they're relying purely on the fact that they met, and that immediately after they met, Watt essentially did this assassination,
the
and they partied
allegation
afterward.
and the imprimatur of Detective Sarah's testimony as to gang membership, and indeed the existence of this as a gang, which even according to Detective Sarah, had no signs, no language, no tattoos, and seemed to consist of 6 guys who shared one bicycle and who had to leave the gang headquarters when the mom wanted to vacuum it. We're not talking here. I mean, they have one bicycle between them. They just have fancy names and a lot of bragging. And I want to come back to the bragging, too, when we separate these. I mean, Actually, I want to go back to the 50-page brief limit. I didn't brief this as a sufficiency case. But even if you took every piece of contested evidence that was presented here as against Mr. Mattis, you don't get any more than involuntary manslaughter. You get somebody handing someone, even if you believe the late concocted, I overheard a conversation I couldn't have, you still don't get any more than someone handing someone a gun and saying, go take care of that. And that isn't go kill them. Particularly where...
You do have immediately after that word is said, he hops on the bike and he essentially attempts an assassination. So you have the proximity in time.
You have proximity in time, but there's a lot of reasons one person might give another person a gun.
To go hunt another person down?
To go scare another person, to go threaten another person. We have a series of cases which are, I think in my reply brief and in my brief, Commonwealth versus Tavares. If you give someone a gun and the other person shoots somebody, you're not there isn't a necessary inference that you intended the shooting. There isn't a reasonable and probable one. And that's why the Commonwealth had to present Detective Sarah to create a shared intent in this case, and that's why Jeremiah Rodriguez in the middle of the trial had to come up suddenly with a conversation that he could not have witnessed. So if the defense had presented credible evidence that Jeremiah Rodriguez was telling the truth at the grand jury when he said he heard nothing and could hear nothing, and was making it up or mistaken when he said suddenly at trial with no further notice after talking to the prosecutor for years, suddenly came up with, this is what I overheard.
So it's raised in terms of ineffective assistance.
Yes.
So,
I raised the first claim.
Right,
And,
right.
and I say,
it takes me a while. Okay, let
I'm
me ask the
sorry.
question.
sorry.
So it's raised in terms of ineffective assistance, and this was sprung on defense counsel
yes,
mid-trial,
the
right?
news came to, the conversation surprised everybody.
Right, so what would a competent defense attorney do who would be surprised by this? Because you said hire an auditory expert and do all that. So what would a competent attorney do mid-trial? It
When-
doesn't, it
yes.
might go to 33E in whether this is consistent with justice, your claim, but I'm just wondering about the ineffective assistance. What would you have him do or her do?
A competent attorney would have sent someone out there to see if this was even possible. Yes, a competent attorney would have asked for 4 hours continuance to go see if it was possible.
They had the view before then, right?
Yes,
So that all the maps, and they went on a view, they saw the porch, saw everything like that, right?
Judge, I understand trials really stressful. I don't do them. But if you could say it the other way, maybe I should have briefed it this way. Maybe I should have said, it's newly discovered. He couldn't possibly have heard that conversation. But it's not immaterial that he didn't, that he couldn't have.
Like I said, it may go to 33E, it may go to newly discovered, it may go to Rule 30 motions, but I get your point.
And my second point, I hope you also get, which is, if he didn't overhear that conversation, or even if he overheard what he thought he heard, he didn't overhear, go kill them. And in order to show shared intent in a case where the only evidence of motive is really Sarah, and where, especially if you comb through this record and separate Watt from Mattis, you don't see civilian witnesses saying Mattis. You just don't. And you don't hear those, you just don't see it. You have to separate it out, because joint venture, you have to have a shared intent to kill, not a shared intent even to shoot their feet.
Before you run out of time, could you address the extraneous influence
Yes, please.
argument?
I may need some extra minutes, Judge. I'm sorry. Yeah.
Let's try it.
Let's try. Okay. The first thing is, this was not a slam dunk. This jury was out Tuesday, Wednesday, and Thursday on this case. They were thinking hard. And of course, we don't know what they said to each other, but we do know what two jurors said to themselves. They said to themselves, these guys are flipping gang signs. They're members of a gang. We know they said that to themselves.
And at least one of the jurors, they disagreed, but at least one of the jurors said it was mentioned during deliberations.
Yes. And the trial judge credited that it was mentioned during deliberations. And they also mentioned, the trial judge also credited that one juror spoke to another prior to deliberations on the way back from the jury box following the testimony of Kimon
Now, the
Elliott.
interesting issue here is whether it's extraneous, and that's, I guess, the big issue. You wouldn't dispute in the cases relied upon by the trial judge, were they signs like throat cutting or something like that? There's no interpretation required by that, and the ruling by the trial judge is almost like, well, the defendant did that at his or her peril, right?
So that's not what they were. The reason we believe that's not what...
So the question was, if it was something that didn't require interpretation, that's a different issue,
Yes.
right?
But this was something that the witness was testified that he was an independent journalist had done a series on gang signing and could not recreate the gestures or make any of the symbols due to the passage of time, but was aware from his own training and professional experience that what he was seeing was gang signs. The other juror testified that it was gang signs, and he recognized them from TV to be gang signs.
If we had a juror in response to an inquiry said, I saw the defendant glaring at the cooperating witness all day,
That would be fine.
that'd be okay.
Demeanor is not what we're talking about. What we're talking about is someone reading Chinese. And by incredible coincidence, Commonwealth versus Cologne and Commonwealth versus Robinson deal with this exact problem. And in both those cases, this court has recognized that if a person has a Chinese tattoo and one juror says to the other jurors, that tattoo is in Chinese and I can read it, or that tattoo is in gang and I can read it, and interprets a sign, a tattoo sign, to the remainder of the jurors, the juror using independent expertise to read Chinese or to read a tattoo, as in Cologne and Robinson, is definitely extraneous influence. It's not demeanor because it requires interpretation which relies on a juror's single outside sophisticated knowledge to interpret to other jurors. The jurors who are reading sign are reading a language which is not available to the others. It includes, and the fact that they think that the defendants are speaking a language is actually contrary to all the testimony adduced on this topic at trial. Because let's credit Detective Sarah, he says this gang has no language. So the state of the evidence at this trial is flatliners are a gang but have no language, and 2 jurors say these defendants are speaking their gang language and therefore they must be members of a gang.
But the context of it was the victim, the surviving victim, testifying against these defendants, and the attorneys are at sidebar, and he purportedly is essentially, I mean, the gang sign would be fairly interpreted as an intent to intimidate the witness, saying you're vulnerable to other members of my gang if you testify against me. I mean, so it is I mean, can it not be fairly construed as an attempt to intimidate?
We have no idea, Judge, frankly. And frankly, one of the reasons we have no idea is because the trial judge peculiarly refused to inquire of the other percipient witnesses. The defendants take the position they must have been going like this and putting their hands on their head because 6 of the people who answered the questionnaire said we saw nothing.
So who are the other witnesses?
We have 12 jurors and 2 alternates.
Right, but
and the trial judge declined to interview.
Only 2 of them responded to her questionnaire, right?
No, 5 more responded and said nothing happened. We saw nothing. And she declined to interview the jurors who saw nothing, and she only interviewed the 2 with specialized outside knowledge who thought that they saw gang signs.
He has an incredible caution from our case law of not getting into the deliberations.
She didn't have to ask deliberations. She was still trying to determine what happened in that courtroom in that day.
You wanted her to bring in the jurors who said they saw nothing?
Yeah, because that's evidence that nothing happened and that these 2 other jurors were in some way prejudiced to interpret effectively innocent hand gestures by young black people having been primed by Detective Sarah.
How does it help to have the people who said they saw nothing come in and say to the judge at sidebar, we saw nothing? What more do you get from that? I'm just trying to understand, because I get that a couple people saw something, but if people saw nothing, there's nothing else to say, is there?
Well, if a juror were to come in, say juror 3, 5, 7, 9, 12, or 14, and say, I was watching the defendants the whole time, and there were no gang signs, Sheldon Mattis was scratching his ear, then it would have been much harder for Judge Roach to conclude that the defendants forfeited their right to a fair trial on a first-degree murder case based on deliberately disruptive misconduct. If 11 other jurors and alternates had come into the room and said they were behaving nicely and they put 3 fingers across their head, and I saw nothing like what these 2 other jurors reported, that would be strong evidence that the defendants were not deliberately disrupting their trial. It would, yeah, so there are exculpatory witnesses on the issue of the defendant's conduct, which the trial judge declined to interview despite 5 years of requests. And if they had said that, the judge might have believed those witnesses and not believed the two she interviewed. And I think that's
Wanted her to
pretty
say-
clear.
You wanted her to ask juror number 13 whether 5 years ago, did you see someone scratch their head?
No, I wanted her to ask jurors 13, did you see these defendants, were you watching the defendants at counsel table, and did you see them make violent gang-related signs which disrupted these proceedings which were threatening to a witness? Yes, I wanted her to ask that, and I have every reason to believe their answer would be, we, like jurors, the two jurors who testified, were observing the defendants, and we saw nothing like what they report.
Here's the dilemma. The dilemma is that we have many, many cases in which we have somebody in the courtroom, maybe a defendant, maybe a family member, maybe another gang member, doing things that may be designed to intimidate a witness on the stand who's testifying against them. And we have jurors who are very observant at watching everything a defendant does and other people. So if we begin to open the door to say anytime a juror observes anything in the courtroom which the juror understands to be intimidating, that is extraneous evidence and requires that juror to be dismissed or a new trial to be ordered if that doesn't happen, don't we essentially encourage or invite intimidation because it will give an avenue of appeal that wouldn't otherwise be there?
Judge, we would be hard-pressed, I think, to say that these defendants 5 years prior to the decision in Moore were planning to reverse this verdict.
I'm not suggesting that they were, but the fact of the matter is, it's not that unusual, in my experience, 11, 12 years, for jurors to see almost everything that goes on in a courtroom and to see everything a defendant does and to see their interactions and to be observing their demeanor. And sometimes it's not so good for a defendant. But if we view all that as extraneous evidence, aren't we opening the door to a lot of stuff?
Judge, we're talking about language here. We're not talking about demeanor. We're talking, there's no reasoned jurisprudence to distinguish gang signing, a language, from Chinese. You have held, in Cologne and in Robinson, that reading a Chinese tattoo, one juror to another, is extraneous.
Yeah,
There's
well,
no reason.
Robinson was, first of all, easier because it occurred during the trial and the juror was dismissed, and that particular juror also saw that as a sign of the decline of young people and spoke to them about all sorts of other things. So there was more stuff in
But the
Robinson.
determination that reading the sign was extraneous. In Cologne, where she reads the Chinese tattoo on the person's neck, what reasoned jurisprudence allows you to say reading a Chinese tattoo, one juror to another, is different than reading a sign language portrayal or recognizing something to be sign as different from Chinese? And there's no argument that can be made in this case that whether or not the defendants were gang members of a gang with a language was central to this case.
I don't know if it's a difference that matters, but the tattoo you bring into the trial, that's what you have. And going to the Chief's point, jurors are pretty darn observant. And what a defendant is doing from defense table is different from what they have on their body. And we tell jurors all the time to consider everything, demeanor, and
But
they can certainly look at the defendant's conduct in the courtroom.
But demeanor is not speech. This is what the two jurors were alleging was speech.
If the defendant got up, and one of the cases cited for us in the briefs even mentions it, and makes some comment out of turn, it's not a mistrial, and the jury calibrates it in their deliberations, the conduct.
But there's a record, and there's inquiry, and there's a procedure, none of which occurred here. The defendants in this case say they made no gestures. No one has established that they have. 2 jurors recognized sign language based on some research they did for a newspaper 2 years ago. It's not the same. We can't take the risk in this one case of forfeiting Sheldon Mattis's right to a fair trial on a murder case where he scratched his ear, and 10 jurors who haven't been interviewed might likely say, yeah, I saw him, he scratched his ear repetitively.
I'm actually unclear. So the one juror was the investigative reporter, and he said, I rode around with Boston PD and gang signs. The other juror never talked about the basis of his knowledge.
Television.
Oh, okay, that was,
He
was the
watched a
television.
lot of gang shows on TV.
Okay, that was it. Okay.
And it's uncontested that at least one juror discussed it with one other juror, and one juror, whom the trial judge credited, said the gang signs were discussed during deliberation. So that means the question of whether these guys were gang members was at issue in this case. It wasn't just clearly established by the testimony of the child that's schizophrenic, and it wasn't just clearly established by Detective Sarah. What they talked about was something that contradicted the expertise of Sarah, and in the first note they say that's all they wrote. The game was over when the signs came out, in the opinion of at least 2. So how can we say this trial was fair when we haven't even determined whether there were any signs at all? And that's a real issue. I want to speak to sentencing for 3 minutes.
Okay, we will in a
Judge.
second. I just want to get, so if you have a defendant who is sitting at counsel's table with his middle finger extended during the testimony of the key witness, the juror sees that and says he's giving him the finger. New trial?
Judge, that's a commonly understood sign.
Not when
No
it's, not when
juror,
it's sitting on a table.
pardon me?
Not necessarily when the finger is sitting on the table. When the finger is up in the air, it's a commonly sign, but
It's subject to interpretation by those who see it a finger on the table is in English. But what we're talking about here are 2 jurors who interpreted signs to other jurors and who used specialized understanding by their own testimony to interpret what they saw. We're not talking about one finger out, we're talking about Chinese. Particularly in a case where the expert said they don't speak Chinese.
I get it.
So
Okay,
I would
let's
like
turn
to
the-
speak,
let me
can I
just-
speak to sentencing?
You can. I just want to make sure that I understand. I gather you asked Judge Roach, can you offer expert testimony with regard to 18 and 19, or 18-year-olds at least, being in the same position as juveniles with regard to their mental and psychological development, and she did not give you expert funds to do so?
The reason was the Commonwealth conceded, per Jack Zanini, that there was no neurological difference between someone or very likely no neurological difference, and he didn't need expertise to say that someone of 18 in one day was neurologically different than 17 and 364. What the Commonwealth said and what the Commonwealth argued below, thus obviating the need for expertise, was that there was a necessity for a bright line rule. And what the judge did was punt it to you. And the Commonwealth took no objection to my entering the testimony which you have before you as transcript and I think a thumb drive, the cross-examined testimony of Dr. Lawrence Steinberg, who you cited, and Diachenko on this issue, that there's really no reasoned scientific basis for a bright line rule of your 18th birthday as establishing psychological maturity, and the science doesn't support. I'm going to use my time.
Generally, before we were to do that, we would generally have a record that is more than one doctor's testimony in a Kentucky trial, which is what we have here.
You have that. You have the scholarship offered to you by amicus on this case. You have actually the scholarship offered to you by amicus in the Garcia case. You have what I want to say common sense and understanding that nothing happens on a person's 18th birthday from every bar mitzvah you've ever been to, when some are big and some are small and some are short and some are tall. There's
13,
nothing
they're
that
only
happens.
13 when they're bar mitzvahed, but,
But nothing happens on a birthday. We know that.
all right, but,
The question is, can we have a bright line rule in the face of the originally decided Florida, Hall versus Florida, and following that, following your decision in Chakwizi, Moore versus Texas, which changed and elucidated jurisprudence on bright line rules when interpreting cruel and/or unusual punishment. The question that the courts look at when they look at whether you can have a bright line rule, I'm not arguing here, and I'm arguing, first of all, I'm arguing in agreement with Berkshire and with 3 counties in agreement with me. It's extraordinary. And I want to say, Suffolk County does not oppose the result which I'm seeking here. I'm arguing
Their brief as this is a legislative issue.
correct. And that's clearly wrong, because this court in Diachenko shows that's wrong, and the
we
Eighth
were-
Amendment shows
that-
it's wrong.
Dianchenko, that was following a whole U.S. Supreme Court line, case on sentencing and constitutionality. That's different than changing the rules and the statutes and the outcomes of first-degree murder cases.
In Diachenko, under Article 26, this court reached a conclusion contrary to legislation which was stronger than that, was more supportive, more pro-defendant than the Supreme Court reached in Miller.
Maybe Judge Spina was right.
but we could piggyback off of the science that was used in Miller, because Miller said 18 and we said, and Diachenko was less than 18.
So we could piggyback. We know.
We can't piggyback because the U.S. Supreme Court says it's still 18, and so we'd have to piggyback off of Dr. Steinberg's testimony in Kentucky and then grab stuff from the amicus. It's an unusual posture for us to be extending a constitutional rule from 18 to 19, which is all we need to do here.
Judge, this is a gentle approach. I'm not asking you today to extend Diachenko. I am asking you to, what the cases speak to.
I'm sorry, so what are you asking us to do? We could
Yes,
drop it to
all
murder
right.
2, obviously, but.
Let's do this. What the cases talk about in the jurisprudence of cruel and unusual is eliminating, reducing as much as possible the risk to an individual person that the punishment is unconstitutionally cruel. That's what Miller speaks to. That's the language of Miller and Graham and Roper, that you want to make sure that a confinement, a sentence, a mandatory sentence, is not unconstitutionally cruel, that no person who should not be confined is confined. So what we're talking about here, what I'd like the court to do, at least for now, which the court requires no more to do, this court can say 18 in a day is not neuropsychologically different from 17 and 364. But this court can say, just to be on the safe side, and that's not an administrative decision, that's a constitutional consideration. We can say, not mandatory for 18 to 21. We can say discretionary for 18 to 21, because some of these 18 to 21s will be youthier than others. And we can defer to the trial judges. And the trial judges wouldn't be the last stop on the freedom train either, because every person, first, we would have hearings, and trial judges could determine, is this person irredeemably depraved or not? And then after the trial judges were made their determination, there would still be a parole board determination later. So the chance of a dangerous person
Right, but that's
getting
still,
out.
but that's, we still have a statute which says it's life without parole for first-degree murder. We have Dyachenko and Miller, which says it is cruel and unusual to impose that on somebody who's 18, who's less than 18. We would have to extend the constitutional prohibition with regard to cruel and unusual beyond 18 to do what you're asking us to do.
You would have to extend the constitutional prohibition only against mandatory sentencing, not against the absolute possibility of sentencing. That would be under Article 26, which is what I press here today. I don't forfeit the federal question, but in terms of Article 26, what you would need to do is say 18 and a half is not so different from 17 3/4 to reliably say it's that the sentence, a mandatory sentence, doesn't violate Article 26.
When the DA says, well, what about 21 and 364 days and 22?
We're going to take this in pieces. We're going to say that's a,
Age 34,
you mean starting the downhill slide?
starting the down here decline, yeah.
I can't answer what, the question here is, what this court says is, we'll defer the matter to another day. We're afraid of a sliding slope. But when the court is this risk averse, it's an unconstitutional assessment of what risk matters.
No, the point is that there's always a line. And why should we have that line for any mandatory minimum, not just murder, and why should it be 21 to 22? There's lines, and the question is this line here unconstitutional? Because the line's going to keep on moving, as you know, with the next case.
Because you don't have, what you're talking about here, what we're asking for here, what I'm asking for here, is to make a sentence non-mandatory. So I'm not saying here that no person of 18 could ever get life without parole.
A person that's 22 could.
I'm not there yet. When I'm there, if I live, I'll be here. But right now, we know there's a group of 18-year-olds and a group of 19-year-olds who are constitutionally entitled to an opportunity to argue that they are youthful in the same way that someone 3 months younger is youthful. And what we're doing is we're giving the judiciary the power that Article 26 intended the judiciary to have over people who are young. And we know that Article 26 intended the judiciary to be in control of sentencing of youth because they are so vulnerable. And the fact that, you know, you could look at the letters submitted by the other district attorneys. Look at what Suffolk says. Basically, it can't be right. Look at the fact, forgive me, look at compassionate release. We don't have life sentences anyway anymore here.
Now you're getting into a different issue.
No, we're looking at
medical releases
the feeling of the people of Massachusetts.
Right, but we don't focus on the feeling of the people in Massachusetts. We focus on the constitutional interpretation of what constitutes cruel and unusual. Let me finish. In Dyachenko and in Miller, the U.S. Supreme Court and we found that children are different because based on the brain science, and the brain science at that time was focusing on children 18 and below. If we are to extend that, it would have to be based on the argument, I would think, that 18-year-olds effectively are still children in terms of the brain science, but the problem I have in this case is I don't have the record that we had in Dyachenko relying upon the Miller record. because, and maybe, and it's not your fault, it's because the judge did not permit you to offer that record. That's the dilemma that we have, that we have here, is that for us to make the finding that children who are 18, which is all you need, in this case, are still basically children, and that the brain science is not fundamentally different from a 16 or 17-year-old, would require us to have a record, and that's the dilemma that we're in.
So say we're waiting for the record. What is the constitutional status of a person who is 67 now, waiting now, that 67-year-old who was 18 and 2 weeks? You know, this court knows that someone who was 18 and 2 weeks is not different than someone who was 17 and 364 days. You don't need Dr. Steinberg to tell you that. You know that. What it is at the far end, I can tell you. But you know today that 18 and 2 weeks is not different than 17 and 364 days, and the Commonwealth conceded it below. So what happens to that person while this court waits for the record on under 21? What should happen to protect that person's constitutional rights is this court should say it's not mandatory, it's permissible. And that way, every person who's in that group, while we wait for the record, has an opportunity to show that as to him, as applied to him, he was young. He was not irredeemably depraved. She had the capacity for reform. That this sentence, as applied to that person, while we wait for the record that the court wants, that person could be in this group where judges decide and the parole board decides. And that way we don't take the risk that the legislature has overreached while we wait. Those people who could and should be constitutionally freed are nonetheless confined. We have to assess that risk in the favor of the defendants who may be unconstitutionally detained, because if they're really bad people, the judges are going to keep them in jail. If they're irredeemably depraved, we're going to know it by the time they're 62, and these trial judges are going to say, whoops, irredeemably depraved, I don't need a mandatory, this is my permissive. And the ones who aren't irredeemably depraved, that cohort of persons who have become ministers, who have helped young people, who have trained the rescue dogs, who have contributed to society in every way, who have been recommended for commutation repeatedly, that group of people is entitled to a constitutional protection now.
Okay, thank you.
That's the argument.
Thank you. Ms. Kesselheim.
Good morning, Your Honors. May it please the Court. Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. The Commonwealth respectfully requests that this Court affirm the order denying the defendant's motion for a new trial and affirm their convictions and decline to exercise its power under 33E.
Yeah, I don't get that. I don't get what you're asking us to do. You write, page 86, note 44, the DA does not believe that such disparate sentences for emerging adults convicted of identical crimes serves the interest of justice. So we have, under 33E, we have to determine whether or not a first-degree murder conviction from Mr. Mattis is consonant with justice, and you're telling us it's not. So are you saying that we should drop it to murder 2?
No, absolutely not, Your Honor.
So what you...
But we can't
Why
change
are
the
you?
sentence.
Why are you asking us to do something which you say does not serve the interest of justice?
So the DA's point on this is that she recognizes that the sentences in this case are disparate. You have a 17-year-old defendant and you have an 18-year-old defendant, and by virtue of when their birthdays are, their sentences are disparate. The DA goes on to say that while she might support legislation that would change the sentencing scheme for adults, for juveniles and emerging adults, That is a legislative process that needs to take.
But you know that it's a constitutional process. You know that Diachenko was a constitutional decision.
That's correct.
So it's a
and that-
constitutional decision that we have to make, and it's also a 33E decision that we have to make.
Well, I think the 33E decision that this court needs to make is a determination of whether the evidence presented at trial justified a verdict of first-degree murder for both of
No,
these
the
defendants.
issue is
And
not the sufficiency of the evidence, it's whether it's consonant with justice. We have many times dropped a case from murder 1 to murder 2 where we found that murder 2 was not consonant with justice. I give Brown as an example. So we have to find that it's consonant with justice. You're telling us it's not, but that we shouldn't drop it to murder 2. I don't understand how you can do that.
I think the verdicts in the case are consonant with justice. Both of
You
these
said it does not
defendants.
serve the interest of justice for him to get life without parole.
The sentences, the fact of disparate sentences between a late 17-year-old and an early 18-year-old, the fact of the disparate nature of the sentences is a difficult question, and it's one that perhaps the legislature needs to address. As of right now, the legislature has drawn a line between juvenile offenders and adult offenders. In this case, and this court, as recently as in Garcia, has determined that the line drawn for 18-year-olds is constitutional. That's the line drawn in this case. As I believe it was Justice Lowy pointed out, or Justice Cypher pointed out, that we draw lines in society. And there will always be someone close to the line.
But the line in Diachenko and Miller was set based on the brain science, that these are children, and that children 18 below, because of their brains, it's cruel and unusual to impose life without parole. And we went beyond Miller to say that a judge may never impose life without parole. The argument here is the constitutional argument that says 18-year-olds are still, for all practical purposes, children.
Correct.
And that's
there's-
cruel and unusual for them.
That's the argument, but on the record before the court in this case, there's not a basis to change
Okay,
that,
but it's a
rule.
record because the judge didn't give them expert funds to do it based on your concession that it was not necessary because indeed you agree.
I disagree with my sister's characterization of the concession made below. The Commonwealth never, the way it was phrased in the reply brief is that the Commonwealth agreed that there is no difference in the attributes between these two defendants and nor between 17 and 364 days and 18 to 21. That's different than the concession made by the Commonwealth, and I would direct the court to the March 12, 2017 hearing at page 13 and 14. The Commonwealth did acknowledge that even this court recognizes that human brain development is on a spectrum. It's on a temporal spectrum, and that the U.S. Supreme Court and our court have drawn a reasonable line. And the concession was that the defendants could go to the Supreme Court, to this court, on the record in the case before it, that is the affidavit of Dr. Steinberg, and make an argument that it should be changed. But that the status of the brain science at this point, and on the record here, was not sufficient to warrant a changing of that line. And again, the case was
So
argued.
I don't, so are you saying that basically in terms of the brain science, 18-year-olds, which is all we need to decide here, are the same as 17-year-olds? Is that something that you say you concede and therefore we don't
No.
need expert testimony to demonstrate?
No, I don't, we don't.
But what is
concede
your
it.
position? Are 18-year-olds in terms of the brain different enough from 17-year-olds that that line is an appropriate line?
I don't think that there is established law on where that
No,
line
it's
is
not
drawn.
established law. That's for us to be, we're the ones who are going to have to establish the law. We did Diachenko, we went beyond the U.S. Supreme Court, and now the question is, should we go beyond the U.S. Supreme Court under Article 26 and say the line should not be at 17, the line should be at 18?
Correct, and as recently as this summer, 2019, in the Garcia case, this court declined to hold that a defendant's sentence of life without parole is unconstitutional. That defendant was 19 at the time.
Right.
And this court cited the minimal record on brain development and said that,
There was not much of a record before us.
right, and there's not much of a record before the court in this case.
So, but that's, all right, I mean,
That's,
It's
on the
a
basis.
problematic position, frankly, for the DA to be saying it's not consonant with the interest of justice, does not serve the interest of justice for us to, for this person to have life without parole, and then oppose the introduction of evidence to give us a record which would allow us to reach the constitutional issue, and then say that we should do something which does not serve the interest of justice, which is what you're doing right now.
I don't think, I think it's a slightly different position. I think that the DA's position, personal position, is that perhaps this warrants further, further discussion by the legislature, further discourse amongst legislators, among the people of Massachusetts, among social scientists, to determine whether the sentencing scheme established by the legislature for first-degree murderers who are adults at the time of their murder is something that the legislature should continue, or whether that law should be changed, and that this DA may indeed be supportive of changes to that scheme. But the question before the court is whether that scheme is constitutional, and on the basis of.
It's kind of a rubber meets the road issue, because the other DAs have weighed in on this case, which is not their case, and said, we agree with the defendant. And here, the DA is basically saying, in spirit, I agree with you, but I don't agree with you.
I think that she's saying, in spirit, I agree with you, but it's not, this case isn't the case to change that based on the record in this case, and that it's not the DA's job to create the law, it's the legislature's job to create the law, and the DA's job to enforce the law.
But as the chief said, you could have conceded and say, we agree under Article 26, 18-year-olds are different, and they're entitled to Diachenko protection.
Again, I think that there's some, this is, as you've seen, from, from Colton to Garcia, this is an area that's changing, and it's changing, by the year. And the question is, at the time that these defendants were sentenced, what were their sentences constitutional? And again, it's not a case where when the court reviews under where this court reviews under 33E, the question is whether a first-degree verdict is consonant with justice, or whether some lesser verdict is more consonant with justice. It doesn't evaluate the sentence and whether the sentence was fair. The sentence is based on what the legislature determines the sentence is for first-degree murderers, where the murderer is an adult.
Counsel, when was the case tried?
This case was tried in 2013.
So it was before your DA was elected.
Correct.
So you're in a bit of a bind in between a trial that was conducted under a different DA and a DA with a different philosophy. Conceptually, I mean, I understand her philosophical point, and I understand your legal point. I'm just trying to point out why there might be some incongruity in your argument.
Conceptually, there's a difference. Again, I want to reiterate the point that our DA's position is that the legislature may indeed want to change the sentencing laws for adult offenders, but thinks that is something that needs to happen with various stakeholders, including the people of Massachusetts, being able to weigh in on that issue.
And the motion for new trial and the request to obtain funds for expert testimony was on the watch of this DA.
No, that was on the watch of the former DA.
That was still on the watch of the earlier DA?
Yes.
Okay.
Now, on 33E, earlier in the year, in a revise and revoke case, Commonwealth versus Tejada, we said that the judge in the revise and revoke could consider the disparity in sentences between co-defendants in ruling on a revise and revoke. And why wouldn't that be a fair consideration under 33E here?
Because again, the legislature has determined, again, that adult offenders who are convicted of first-degree murder are punished differently than juveniles convicted of.
I understand. I'm only in the 33E issue. I understand. but in 33E, when we're determining the circumstances and whether or not sentence is consonant with justice, I'm saying that one of the cases this year, we decided that in a revise and revoke context, that we could consider the disparity between sentences of co-defendants. And I'm wondering why, in the interest of justice, considering the disparity here with such a minuscule difference in age, why that wouldn't be a factor that we would consider under 33.
I think because the sentencing scheme for adults convicted of first-degree murder is set. That's in Massachusetts, if you are an adult and you are convicted of first-degree murder, then you are sentenced to life without the possibility of parole. So the disparity results from a
SJC, and then we decide whether or not that sentence is consonant with justice.
well,
under
whether
33.
well, I think whether or not I think if the law being how it is, if this court were to determine that sentencing of an 18-year-old to life without the possibility of parole is unconstitutional, which I'm not urging, then it would be different. But I don't think there's a grounds to reduce his sentence. There's no grounds, certainly, to reduce the verdict. And I'm happy to discuss the evidence against Sheldon Mattis, which I think is much more than what my sister alluded to in her argument. But there's no ground to reduce the verdict, and therefore the court's hands are tied with respect to the sentence. If he's convicted as an adult of first-degree murder, then there is going to be a disparity different than two adults convicted of something that's not first-degree murder, where there's some wiggle room in terms of the sentence that they can receive. So the defendants are, by virtue of their birthdays, in different posture when it comes to sentencing in this case. And I think the court's hands are tied with respect to Mr. Mattis, unless it were to reduce the verdict, which there is absolutely no ground to do in this case.
Okay, let's turn to the evidence with regard to Mr. Mattis. What do you say that evidence is?
With respect to Mr. Mattis?
Yes.
So the evidence is that and I think it's important to consider not only the testimony of the civilian witnesses, but also the corroborating evidence. So the evidence with respect to Mr. Mattis is that he went down to the Geneva News store and he scoped out the victim, Kamoni Elliott. And this is corroborated by surveillance video, which captures his face, captures him having the conversation with Kamoni outside the store, captures him going into the store, buying the rolling papers and nothing else, as Kamoni said that he did, coming out, having another brief conversation, and then moving away. Kamoni Elliott testifies that what was said to him was what he asked him to buy. Kamoni asked Sheldon Mattis to buy him the rolling papers. He agreed to do that. He did that. And when he came out, he asked, "Where are you from?" To which Kamoni Elliott responded, "I'm from Everton." There was testimony from both civilian witness and Detective Sarah about an ongoing feud between Flatline and Geneva Everton. Sheldon Mattis then goes back up to outside the gang headquarters at 6 Levant Street, has a conversation with Defendant Watt. And that conversation is overheard by Jeremiah Rodriguez. He hears him say, he sees him pass him a gun and say, "That's them kids," right there, and tells Defendant Watt that he needed to go handle that. Defendant Watt is then seen leaving on a bicycle, and a few minutes later, shots are heard. The shooter is described as a description that matches Sheldon or Nyasani Watt. He's described as wearing a red shirt, a dark-colored Boston Red Sox hat, driving a bike with straight handlebars, and having braids in his hair. And that's by both civilian witnesses and by Javon Blake's brother, who saw it from up the street. Nyasani Watt is captured on video and identified at trial as the person in a red shirt on a bike. And then hours later, he is seen sitting on the steps outside the gang headquarters, having the braids taken out of his hair, When he's asked why he was having the braids taken out of his hair, he said that he needed to change his look. When the mood that night seemed celebratory. They were asked he was asked why he was celebrating, and he said something to the effect of, because of an accomplishment I did.
He being Mr. Watt.
Mr. Watt, right.
So let's go back to Justice Gaziano's questions of your sister. I understand that it may not be ineffective of counsel who learns during the course of trial. Do you, by the way, agree that J.R. said nothing about what was said until trial?
Yes.
And did J.R. say anything before trial about seeing the gun transferred?
I believe he saw them meet, I think he said he saw them meeting near a car or beside a car. I don't believe there was testimony about the gun
So
transfer.
basically, so the information about the gun and what was said is, defense counsel is hit with that during the course of trial.
Correct.
All right, so I understand why at that point, all but the most alert counsel may not necessarily have, well, but regardless of whether it's ineffective to send an investigator to the scene, they have done so since trial. And I've looked at the affidavit of Mr. Diaz, who says that that J.R., if he was at that position, that not J.R., but nobody could have heard a conversation from where J.R. said he heard it. Do you agree with that?
No. First of all, Mr. Diaz is an investigator. He's not, there's no claim that he's any sort of auditory expert. There's no claim that he has analyzed JR's hearing. There's there's nothing in his affidavit to indicate he knows anything about how human hearing works other than his own personal knowledge. He goes out with a paralegal from the firm, and together they make this determination based on nothing but their own observation at the time. That's simply not expertise that lends any credibility to the argument that Mr. Jeremiah could not have heard what he heard from where he was. I would also note that Jeremiah, two things. The jury did go on a view, so they were able to see the relative locations of these two places, the Geneva News store, the streets, what happened where. And Jeremiah's credibility, I would say, was masterfully cross-examined by trial counsel, pointing out his past mental health issues, the fact that he had gone somewhere working on truthfulness, the fact that he was recently had a parole violation for not taking his mental health medications. And that's all outlined in the Commonwealth's brief. It was an extensive cross-examination. It was also relied upon extensively by defense counsel in closing about how Jeremiah was not to be believed at all. Now,
Did that include the fact that this was a surprise, that he had never said this during police interviews or grand jury?
yes, he was cross-examined on that point about the fact that he'd never told police about that, and he hadn't mentioned that in his grand jury testimony, and he was cross-examined about the inconsistency of his prior statements.
But it's his statement to him which is critical to. Without the statement, you have all the circumstances. I understand. You've got circumstantial evidence that he sees this poor kid and learns that he's from the other neighborhood, and then meets, and let's assume, I'll even give you the gun. But the statement matters in terms of that's the direction of him to do something.
Correct, although arguably, if you accept that he went down and scoped out the victim and then provided the gun and then had a conversation with the person who was later identified as the shooter, that lends, together, it's a fairly strong circumstantial case without this statement. Additionally, shirts matching the shirt worn by the shooter were found in his house, so that's further evidence that he may have...
Put aside what? Found
in Mr. Mattis's house.
Okay, so, right, so I understand that, but without the statement, in terms of premeditation, you're left with the circumstantial evidence.
Well, the premeditation, Your Honor, with all due respect, would come from him going down to the store and scoping out the victim and determining that he is from what he perceives as a rival gang.
Is there any evidence that he was scoping out anybody as opposed to just having to run into this kid and the kid asked him to do a favor?
Well, he goes in, he doesn't go into the store to buy anything for himself. He goes in to buy only the rolling papers requested by this victim, and he comes out and has this conversation.
But do we know why, we don't know why he was going there.
No, although he didn't go there to buy anything for himself, and then he comes back and immediately has a conversation with Nyasani Watt. And again, if you concede, that he gives him the gun, then, moments later, that very victim, a 14-year-old child, is shot in broad daylight, and his 16-year-old friend is murdered in broad daylight by a person who is identified as Mr. Watt.
We don't have in the record appendix the grand jury or the police reports relating to this witness, do we? JR's witness?
Related to,
The prior statements of this witness, JR?
no, they're in the clerk's file, they are attached. No, I don't know. I believe that
I'm looking at
Jeremiah's
the
grand-
addendum. I don't see them.
I don't know. I can certainly provide them to the court. I know that they were relied upon in court during cross-examination.
Could you provide those to us, please?
Sure. But again, I would note that the cross-examination of Jeremiah was extensive and was relied upon again extensively in closing.
So, but I mean, is there any dispute that JR has serious psychiatric issues?
No,
Is there any dispute that that among those psychiatric issues is him imagining things that never happened?
that was certainly evidence that the jury had before it. I can't speak personally to all of Jeremiah Rodriguez's mental health issues. I can speak to what's in the record before this court and the trial transcripts, and the fact of his mental health issues was exhaustively brought out, including notation that he had from one of the programs he was in saying he was working on truthfulness. That was and the fact that he amongst the symptoms of the mental health issues he suffered was that sometimes he sees things that aren't there. So all of that was before the jury, and it was the jury's job to evaluate the credibility of that witness.
I understand. So all that goes to whether counsel was ineffective. How does that bear on the 33E calculation for us?
I think the with the 33E calculation, you have to consider all of the other evidence that JR provided that was corroborated by other civilian witnesses. So with respect to the defendant's membership, so the question of that conversation, that only comes from JR. So if this court were to determine that absent that conversation, either that the jury improperly considered that conversation or absent that conversation, he couldn't have been convicted of first-degree murder, which the Commonwealth in no way concedes. If the court were to make that determination, then there's no other witness that provides that, certainly. The other witnesses provide the presence of his interaction with Kamoni Elliott. Kamoni provides evidence of the conversation he had, but certainly nobody else provides that evidence. Much of Jeremiah's testimony was corroborated by other civilian witnesses, and I think that's an important thing to note. The defendants make repeated reference in their brief and in their reply brief that the defendants did not self-identify as members of Flatline. That is flatly contradicted by the testimony of various civilian witnesses. I would direct the court to the testimony of Kayla, also known as Shawanda. She testified that T-Mac lived at 6 Levant Street. Shell's suspect, I apologize, many of the civilian witnesses only referred to the defendants by their names. So defendant Watt, his nickname was Suspect, defendant Mattis was Shells. Shell's suspect, RG, New York, all hung out at 6 Levant Street. Suspect, so defendant Watt told her that the group of boys who hung out at 6 Levant Street were called Flatline.
That goes to what we had discussed with counsel as far as the gang evidence and any prejudice perhaps
Yes,
from Sarah's testimony, but it doesn't corroborate the critical evidence that JR gave against Mattis.
That's true. That evidence came solely from JR, but the point that I wanted to make was that perhaps if the jury credited that conversation, which I don't know if they did, because there is other evidence linking him to the scoping out of the victim, the possible aiding the defendant Watt in disguising his appearance by having the clothes matching the shooter's clothes in his house at the time the search warrant is executed at his house, and his celebration of Watt's accomplishment. There's other evidence linking him to this other than that conversation. My point was only that if the jury decided to credit his testimony in that, perhaps that's because much of what he testified to regarding the flat line and the conflict with a rival gang, that was and the defendant's membership in this gang, the defendant's close relationship to one another, that was corroborated by numerous other witnesses. And I would direct the court to Elijah's testimony, Kayla's testimony, and I think JoJo is a very compelling witness for this, for the Commonwealth, because she is a friend of the Rodriguez family who lives there. She testified that she and Defendant Watt were A&F friends, which she described as always and forever friends. She liked these defendants, and she corroborates much of the testimony regarding their involvement with the gang.
On the juror issue, how do you address the issue, the extraneous information? And I get the distinction between perhaps giving someone the middle finger, slicing your neck, which would be apparent, and the defendant apparently would do that at their peril because it's their demeanor, its intent to intimidate a witness or a victim. But here, the argument is raised that what was imported into the trial are the musings of these two jurors, one who was an investigative reporter, another one who apparently watches a lot of TV, that these are gang signs. Doesn't that make it extraneous?
No. So I think it's important to analyze the jurors separately and to pay close attention to what they said they saw and what they said about how they interpreted what they saw. Because my sisters use repeated references to them using their expertise instead of evidence introduced at trial to reach this verdict, and that is absolutely a mischaracterization of what they did and what they said. So with respect to Nathan Eisner, if I could just have a moment. Nathan Eisner was the reporter who served on the jury. Now, I would note of particular importance with respect to this juror that the fact of his experience as a reporter and the fact that he did a series of stories on gang activity 12 years ago, he said, I wouldn't say that I have any preconceived notions. I would just say it maybe increased my familiarity with gangs. That's in transcript volume 1, page 48. That was brought out during voir dire of that juror. He was found to be indifferent, and neither defendant nor the Commonwealth objected to his service on the jury.
He said, well, I don't know specifically that this was in any way gang affiliated. It did seem to resemble what I had seen in my experience doing these types of stories. That's a
Correct.
page 40.
Correct. So two important things. Number one, the fact of his past experience with the jurors bring their life experience to the jury. I'm a mother. I'm a former elementary school teacher. If I were to serve on a jury, I bring those experiences to the jury. Likewise, this defendant, who everybody knew was a reporter who had done reports on gang involvement, brings that experience to the jury.
Was that brought out during voir dire?
Yes, that was on transcript volume 1, page 48. That's his.
So there was either attorney voir dire or individual voir dire, and the person said I'd done, because there was inquiry about gangs.
Correct, and that's the information.
And for whatever reason, all parties left them on.
Correct, because he was found. He said that he could remain indifferent and judge based on the evidence, and nobody objected to that. He was left on the jury. Now, secondly, important to note about this juror is that he very clearly states, first of all, what he said he saw is a hand position, and the gesture meant something to him because in the past he had served as a journalist and he did a piece on gang concerns and gang problems in Boston. That's during the post-verdict juror inquiry. I direct the court to page 39 and 40 of that transcript. But he also says very clearly that he never spoke to any other jurors before or during deliberations about the symbol he saw.
That's a problem, though, because we got juror number 2 who says we discussed it during deliberations, and Judge Roach credits juror number 2.
Well, juror number 2 said he spoke about it to at least one other person during deliberations. So that one other person is not necessarily Mr. Eisner. So, so with respect to juror number 2, Mr. Fernandez, he says that he saw, first of all, both of these jurors speak to the intensity of the interaction, the tension between the surviving victim, Kimoni Elliott, and both defendants. So they both discussed that. But he says that he saw, he said he saw Mr. Mattis made hand gestures and the witness returned them. I'm directing the court to pages 68 through about 71 of the juror inquiry transcript. It was just motions with their hands as if he was pointing or making gestures at the young man. The victim was clearly visibly upset. He couldn't talk without clenching his jaws, and he was looking at both defendants, and they were looking back at him, and there was tension, there was animosity. And that, if he's not mistaken, the witness also responded in kind to Mr. Mattis. He was asked whether the gesture had any significance to him, and what he said is that he thinks he saw similar kinds of motioning on TV before he became a juror. That's at 72 and 73 of that transcript. So he did not say, again, he's bringing his life experience. We all watch TV based on what we watch, TV we watch, books we read, experience we have. We may interpret certain conduct in certain ways, but the jurors are entitled to observe the defendant's demeanor, their behavior in court, if they were, and they're entitled to interpret that based on their common sense and life experience. They were told, they were instructed to judge the case based only on the evidence introduced at trial, and there's no indication that they did otherwise. With respect to the argument that, well, why should defendant Watt be punished for something that only defendant Mattis did, because one of the jurors clearly identifies Mr. Mattis as the person who made the gesture. I would say, number one, the judge correctly found that the tension, the animosity, the staring back and forth, that was between both defendants and the surviving victim, Kimoni Elliott. And that also the jury was clearly instructed that they must evaluate the evidence as to each defendant individually and must consider the evidence carefully as to each of the charges for each defendant separately. And I would direct the court to transcript page 10, volume 10, page 88. So there's no indication that there was an extraneous influence or that any further jury inquiry was warranted.
If I could ask about the gang expert?
Yes.
So there's numerous issues the gang expert can testify to: motive, turf, retaliation, all sorts of issues. And the gang expert can rely on his own observations. He could rely on certain other things that don't come out on direct. If the civilian witnesses had testified first, the 3 civilian witnesses, he could have assumed that in hypothetical or assumed facts questions. But what the defendant is saying here is that you have the expert testify first and indicate what the information is that the police have about these individuals. And then you have the 3 civilian witnesses come in and talk about gang testimony, and that unfairly and to the prejudice of the defendant puts the imprimatur of the gang expert onto these 3 witnesses in a way that's not permissible for expert testimony.
So I don't think that the order of the witnesses is dispositive in this case. I think that the detective was properly qualified as an expert. He testified as to the structure, basically the structure and the functioning of gangs in Boston and during the relevant time period. And the sort of important piece that he gave is related to the ongoing conflict between the Flatline Gang and Geneva Everton, which gives context to the information that defendant Mattis gleaned from Kimoni Elliott outside
Perfectly fine.
The store. Correct.
That's all fine. The issue is that without him having personal knowledge, indicating that they were flatliners, and when he didn't have personal knowledge of that, and there was no request that it come out to Benny based on assumed facts of the next three witnesses.
Correct, and he didn't testify that he had personal knowledge of these defendants being members of Flatline.
That's the problem. If he did, that'd be fine too.
If he did have personal knowledge, right, but so his role was not to identify these defendants as members of the gang. Because he couldn't.
But he added in the collective knowledge opinion.
Yes, and again, were the court to evaluate, even if the court were to assume that that was error, which I don't think it was in this case, but even if this court were to assume that, the question is, would there be any prejudice from that?
But I don't want to leave that, because this is an important case about gang expert testimony. So I just don't want to leap over the issue. And gang expert can't say, well, based on what I've been told at roll call and what Joe told me and Detective Smith told me, I believe he's a gang member. And it's it might not be prejudice, but it's specifically concerning when you have three other witnesses who are saying so, and you can use this collective knowledge of the police to corroborate.
Yeah, I understand the court's point. I think to the extent he was testifying about his knowledge, so he was asked all the various questions. Again, the Commonwealth put him on to explain the structure and functioning of gangs in Boston, because again, to the lay person, this doesn't make sense.
But you could have had him testify structuring gang, well, fourth would be, but even if he testified first, he could have said, there's a beef between these two gangs. I don't know about these two kids, but here's what's going on, and then fill in the blanks with the civilians.
Well, I think
Or have the civilians testify, now it's in evidence, then have him testify.
to be honest, I don't recall exactly how the piece of evidence that came in when my sister was arguing came in. I recall that he was asked repeatedly whether these defendants were members of the gang database, and he testified that they were not.
Right, but then in the section that was quoted by counsel, he was asked, are they gang members? And he says, under our collective view, they are.
Right, though they're not in, they're not in.
But they're not in the brick, but we think they are.
Correct, based on the fact that they hung out at this
Well, no, based on
location.
what all these other people have told me, essentially.
Right, so I guess he did testify, he was not the person, his testimony was not necessary to establish.
Prejudice argument, I understand. That's the prejudice argument. But you don't disagree that an expert cannot import hearsay into the direct testimony to formulate an opinion. They can base their opinion on information that's independently admissible that's not admitted, but they can't be talking about what the word is about whether this person's a gang member.
Correct.
So now you get to prejudice. That's what I was looking for.
And I'll happily get to prejudice, because there was none in this case. Again, you have the testimony of Kayla, and again, this is giving the court rough transcript sites, volume 6, pages 230 to 236, testifies about how suspect told her that the group of boys who hung out at 6 Levant Street were called Flatline. Elijah, so this is at volume 7, 87 to 92. Flatline was a gang and Levant Street was their street. They owned it or ruled it. Suspect told him that Flatline was a gang and they wanted Jeremiah to join. Him and Jeremiah, Elijah and Jeremiah to join. T-Mac was the leader of Flatline. That's at 790. RG, T-Mac, Shell, Suspect, New York, and RG were all members of Flatline. That's at 792. JoJo, who again testifies that Watt was one of her A&F friends, said that Shells, Q, RG, New York were all outside of 6 Levant Street every day. Defendant Watt told her that the name of the group was Flatline and nobody messes with us. That's at 7147. And suspect told her that Flatline had a conflict with Geneva. That's at 7146. Jeremiah then said that in the summer of 2011, he learned that T-Mac was the leader of Flatline. That's at 7247 to 248. The other members of the gang were suspect Shells, RG, New York, that's at 7248. That he met suspect on Geneva Avenue and he told him that the area was hot and that they had altercations with other people, that's at 7250. And that suspect told him that he was from Levant Street. Levant Street and Flatline were the same name for the same gang. That's at 7262. So what Detective Sarah's testimony really did was contextualize gang evidence that was introduced by other witnesses. And the defendant's membership in this gang was very clearly established if the jury were to credit the testimony of numerous civilian witnesses. Unless the court has further questions, the Commonwealth is content to rest on its brief.
Thank you. I think we'll take our morning break.